attorney and trial consultant, Dina Sayegh-Dahl. Dina, great to see you again. Thanks for being with me on the show.
Thanks for having me.
All right, so the question I want to get to is essentially, what do you think the end game is here for Jon Pryor? I understand where he's going with this, and there's two different issues. He's got the impartiality of the jurors at the grand jury level and also prosecutorial misconduct. What do you think his end game is?
I think he's doing a good job of kind of fighting for his client at every step. You know, when he receives this information, as the judge has allowed him to, he will, do his research. He will see if there were any facts here that will support the fact that one of the jurors was biased or that there was misconduct. And if he finds anything, even if it's not strong enough to actually get a motion to dismiss, he's also now just preserved an issue for appeal. So I think that's kind of smart advocating, is at every step try to preserve as many issues for appeal as you can, and if his client does indeed get convicted.
Now we have that secondary issue, this prosecutorial misconduct. Right now, again, we're at a bit of a disadvantage because a lot of the paperwork and filings on this particular case are not public, so we don't know exactly what that misconduct might be. But what if he wins on that? Can the state then bring these charges again? Can they again go to the grand jury and seek to have him indicted?
I think it will depend in part on how the order is crafted by the judge. What kind of misconduct was actually found? Was it so egregious? But you would think that the prosecutors could, or maybe perhaps a different prosecutor, maybe this one would have to recuse themselves if there was indeed that type of misconduct, but that they could try again with a different grand jury.
Now, what's interesting here, and I want to turn now to that motion to sever and the decision by the judge that he would not sever at this time. I want to get your thoughts on that. Because at the end of the day, the defense is claiming that it makes it very difficult for them to prepare for trial when you don't know if the co-defendant is going to be able to be at trial. And I certainly understand that, but there are a lot of competing issues here that I think the judge ultimately got it right.
I think you're right, too. Although I also agree with what you said earlier, that this is going to come back if she's still not competent to stand trial in January when this is supposed to go to trial. It's very possible the judge may allow it to be severed. At some point, even the prosecutors may be okay with it severing. I don't know how many years they would really want this to go by. So I think this is going to be revisited many times if she continues to be incompetent. And if she is deemed to be incompetent and they do decide to sever it, we're going to see a motion from the defense asking for more time for him to be able to recraft his own strategy.
And the truth of the matter is, Dina, that there's really no timetable on competency. It's been 5 months. I've seen cases where it's gone over a year. I think a year is sort of a good estimation as to how long it might take, but really there's no timetable on when Lori Vallow might be ready to go to trial.
Absolutely. I mean, technically, she could never be ready. And I think that there was a high-profile case that we just covered recently. It took about 7 years for him to be able to be competent to stand trial. So we don't know, because this has been sealed, exactly what medically is going on with her, how they're treating her. So it's really hard for us to know, how long she could be incompetent.
Absolutely. But as you said, and as I mentioned earlier, this judge is not going to let that go on forever. All right, Dina, stand by. We're going to take a